The most common mistake in asset protection isn't choosing the wrong structure, it's waiting too long. Asset protection law operates on a simple principle. You can't protect what you've already put at risk. Once a lawsuit is filed, once a creditor claim is visible, once a debt is incurred, any subsequent transfers can be challenged. Any restructuring you do after that point can be challenged as fraudulent conveyance. Fraudulent conveyance laws exist in every state, designed specifically to protect creditors from bad faith actions. They allow courts to reverse transfers made with the actual intent to hinder, delay, or defraud creditors. In the United States, most states govern these rules under the Uniform Voidable Transactions Act. When evaluating actual intent, courts analyze a set of circumstantial factors known as badges of fraud. These badges include whether a transfer was made to an insider or if you retained control of the asset. It also includes if the transfer occurred while a lawsuit was pending. When a transfer happens close in time to a known liability, the intent to defraud is legally presumed. A transfer that looks like standard estate planning 5 years before a claim is perfectly safe. But it looks entirely different when the transfer happens the week after a lawsuit is filed. This brings us to the crucial concept of seasoning periods, which determine when a transfer becomes safe from challenge. Many asset protection jurisdictions establish explicit waiting periods after which a creditor's right to challenge expires. For example, states like Nevada and South Dakota have a 2-year seasoning period, while Alaska has a 4-year period. Once this statutory window closes, your protection becomes active and extremely durable. But to benefit from these timelines, you must act early enough for the clock to run before a claim materializes. The law makes a clear, critical distinction between existing and future creditors. An existing creditor is anyone whose claim has already arisen, even if no judgment has been entered yet. Moving assets out of reach once an existing creditor is on the horizon is considered a fraudulent transfer, and courts routinely undo them. On the other hand, transfers made to protect against unknown future creditors for legitimate business, estate, or tax planning are on incredibly solid legal ground. So, when should you act? The right time is during major life or business transitions. Starting or expanding a business is a primary signal. Liability structures should be in place before you open your doors. Entering high-risk professions like medicine, law, or real estate development is another. Finally, acquiring substantial assets like a property portfolio, an inheritance, or business sale proceeds is a major signal that there is more at stake. Waiting too long doesn't just mean your protection fails, it can actually create severe legal exposure. Attempting last-minute transfers can lead to court sanctions, attorney fee awards, and even personal liability for trustees or nominees who assisted you. By contrast, the cost of proactive planning is fixed and predictable. Timing isn't a mere technicality. It is the single thread that determines whether your structure holds or gets completely unwound. Build your protection structure before the storm arrives, not during its peak. Subscribe to learn how to build protection that stands up when it matters.